rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are on the record in CV20 0637 Heritage v. Weinberg. A couple of housekeeping items as we get started. Please keep in mind that these proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock, which is on the center podium here, to reserve a portion of that time for rebuttal if desired. Also, please keep in mind that we have read the briefs and we have conferenced the case this morning. And with that, counsel, you may proceed.
May it please the Court, Doug Northup and Taylor Bagoon for the intervener appellants, Jack Norman and Jerry Molotsky. And obviously, keeping in mind you all have read this, I'd like to reserve 5 minutes for appeal, and I'll obviously watch my time on that. What's really important to keep in mind here, Your Honor, is this was an appeal from a motion to dismiss, where the allegations in the complaint must be accepted as true. And where the trial court erred in this case was in determining, because CC&Rs in this case, like often do, give architectural review committees discretion to consider and approve some types of changes within a community, that the trial court had no ability to review anything that happened in this case, particularly given the procedural history before. She did not consider the well-pleaded allegations. She actually considered and cited to arguments that were made in briefs by the appellees, and that doesn't meet the Rule 12b standards. There was at least one definitive violation of the CC&R.
Which one is that?
That is the rear wall of the home that was moved. That is a violation of Article 2, Section 6. That cannot be waived.
Article 2, Section 6 says you can't make a change to a wall, and there's an argument at least as to whether that means any wall or exterior walls. But doesn't it also, the next preceding sentence say, and any changes have to be approved by the Architectural Committee?
Not on that one, Your Honor.
Yeah, it does. It actually does say it in the next sentence.
And let's also...
So my point being, isn't that a matter of contractual interpretation, not a question of accepting well-pleaded allegations as true?
Well, first of all, the judge didn't interpret the contract because she felt like she couldn't.
Well, no. I think you could say, if you interpret a contract as saying no changes to the wall, then you have a well-pleaded allegation. But if you interpret the contract as saying no changes to the wall unless otherwise approved by the Architectural Committee, then you don't have a well-pleaded allegation. So how did the judge err in doing that?
Your Honor, there is no claim, in fact, it's admitted in this case, that the rear wall was built outside of its original footprint.
Right.
It's admitted that was never moved back and it wasn't part of the original settlement. That is not something, that was something that Judge Gamma found at the behest after HV2 exercised its discretion and said that's a violation. That has to be fixed. Following an evidentiary hearing, Judge Gamma said, that's a violation. This is not a situation...
And Judge Gamma also said, and now you guys have to go back and figure out how to bring it into compliance.
Right. And
He didn't say you had to move the wall back. He just said, figure out a way to make this all work.
That never happened, though. And that's the problem. That's the reason...
I mean, that's your position, but didn't they enter into a settlement where they agreed to paint and do things?
They didn't fix the wall. And that's our point, Your Honor.
Judge Gamma never ordered them to put the wall back in its original
That's right, but he said there were at least 4 violations of the CC&Rs, and he said, go try to work these things out. What happened, though, before we were to this court, before that settlement agreement was entered into, that settlement agreement preceded the order from this court with a different panel previously. And what happened was, in 2014...
I'm vaguely aware of that prior panel.
Okay, so, but Your Honor, it wasn't like something happened after 2014 or after we were at this court before saying we addressed, the Architectural Review Committee addressed the violations and there were changes made and they no longer are violations. That didn't happen. And that's the allegation in the complaint.
The house was in compliance. Are you saying that the only issue is if they had said the house is not in violation, then it would be okay? I mean, I don't read that as being terribly different.
Your Honor, the only architectural review committee work discretion that was ever done here was in 2013 when they said this is a violation. And our whole point is, this is not a situation where on the first pass, the Architectural Review Committee says, we believe that a 19-foot high roof or moving a perimeter wall, even though we assert that's not subject to discretion under the Johnson Point case, but that this doesn't violate, it's in harmony or conformity, then they would have an argument that there should be deference given. But these were determined violations by the committee, by the board, by Judge Gamma, and there's never an argument made that the settlement fixes any of those or brings them into compliance. In fact, the only evidence is, as we argued before,
Unless we take that the violation was they didn't have the permission. And at the end of this, they now have permission to have moved the wall under the second sentence of that provision.
but again, Your Honor, they have to have, in order to exercise discretion, whether you look at Johnson Point or any of the other cases that we've specifically cited, you can't say on one day, one board says this is a violation and it doesn't comport, and then another board says, no, we changed our mind, it does.
Well, if the violation, though, was failure to get the permission, and then afterwards, and I'm again asking you to just assume for purposes of this argument, not concede, or discussion, that Judge Morse is right, that the second sentence allows the approval. So if that's the case, then once they get the approval, isn't the violation gone?
It is in this circumstance. Again, in the first instance, if there was consideration given and said, all things being considered, we don't think a 19-foot roof height is a violation, arguably so. Now, that in and of itself doesn't preclude a challenge to the Architecture Review Committee, but it would allow some discretion. But this was a determined violation, and it was never repaired. The HV2, again, the arguments were back when we moved to intervene and were allowed to intervene. We gave up. We just ran out of money, and it was determined that the WEINBERGs were never going to make any meaningful changes to this residence. That's why they settled. Not because there were changes made or it was determined that there was conformity. It was, we're giving up, and the only thing that was...
How should that inform our decision? I mean, I'm reluctant to get in the position of second-guessing a litigant's desire or not desire to incur additional expenses anymore. So why does that matter that the committee or the HOA decided it's just not worth fighting anymore?
Well, as Judge Schwan noted when we were here the last time, they absolutely had that right. And in fact, I think his words were, you could sit on your hands, you could do nothing. Remember, we joined in as plaintiffs on the same side as HV2 because we said, wait a minute, if you ran out of money and you're going to capitulate, that's okay, but you can't just give up now. We as homeowners under the CC&Rs have the right to enforce the CC&Rs as well. So sit on the sidelines. Let us take the fight. Let us deal with it, but don't just give up and then also in the process wipe out, vacate all of Judge Gamma's orders so that they no longer have any effect in the case.
But they didn't just give up. They entered into a settlement that provides, as I recall, the WEINBERGs paying $5,000 for some repairs, lowering a parapet, agreeing to paint changes, things like that. So there was something done. It's not like they just washed their hands of the matter completely.
True, but remember, Your Honor, that was all in the record when the court said our clients had an interest to protect. They could have easily said, well, they did something, your interests are protected, whatever it was. But remember,
the prior decision specifically said, and like I say, I'm pretty familiar with it, said, this has no bearing at all on whether the settlement agreements complies or doesn't comply. It was just whether you had a right to weigh in.
And they said it didn't determine how we could participate, but that we absolutely had that right. But again, it's not like anything happened after that. In fact, the court talked about that our clients should have some opportunity to weigh in on the settlement. Of course, that never happened because the settlement predated when we were here in the first place.
Interesting, the court said that, but where did the contract say? We're talking about the CC&Rs, and the absolute authority to resolve this falls to the board. not to a homeowner. Now, a homeowner can challenge stuff, and I understand your point, but there's two parts of it. One, homeowner can challenge, but if the board reaches a resolution that falls within the confines of the CC&Rs and does an amendment, again, I'm asking you, just for purposes of this, to assume that that your argument with regard to the wall is incorrect, then that's within the board's discretion, and you're arguing that you should be able to take that discretion away.
No, not at all, Your Honor. Here's the thing. The HV2, having determined that that was a violation, went to court and invoked the jurisdiction of the court. And the court agreed after an evidentiary hearing that the wall and these other features were violations. At that point in time, the board doesn't have, because again, our clients have the right to enforce the CC&Rs just as the board does. We don't get to impose our will on the board. But again, I think what's so critical is let's look at what Judge Gamma found were violations that had to be remedied. Reduce the height of the house, revise the back patio so the roof line no longer extends to the property line, reduce the courtyard footprint, remove the walls expressly prohibited by the CC&Rs, which Judge Gamma found, respectfully Judge Moritz, that our interpretation, I believe, was correct. That was an absolute. And he ordered these were necessary to comply with the CC&Rs. The settlement that was done in 2014 says, well, they'll pay the draughts $5,000, nothing to do with the violations. Agree to the roofmates painting their house, the draughts getting permission, some veto power over the color of the house painting, nothing to do with the violations that were found. Lower a center parapet and sign an affidavit there were no propane tanks. So again, had the Architectural Review Committee gone back and said, we are requiring action that in our discretion brings these violations so they are no longer violations, they would have an argument. It's not absolute discretion. Johnson Point and the other cases we've cited, that is not unfettered discretion, but at least they would have exercised some discretion. But we alleged in our complaint that never happened. They did not fix the violations that had been found, and the only discretion ever utilized in this case was back in 2013, long before the settlement.
Counsel, if you don't mind, considering you've only got about 3 minutes left before your time you're reserved, talk about the fees, and talk about two specific areas of fees. One is whether the Heritage Award of fees was appropriate in its entirety, and two, whether this court should consider, or what support do you have for your argument that this court should look at the intervention fees as a separate and distinct?
Well, first of all, on the HV2 fees, those cannot be recovered under the CC&Rs. The CC&Rs talk about, in every section of the provision that applies, the party against whom action is taken. HV2 did not take any action against my client's L. So the award under the CC&Rs is just outside compliance with the contract. In terms of...
I agree with you on that. But the court, as I read it, said separately, and if I'm wrong in this, I would still award fees under 341.01. How do I deal with that?
Well, Your Honor, a couple things, and I'll answer, I think, both of your questions here. 12341.01 requires the parties to be adverse, and for example, the Fulton Homes case that we cited, to be adverse, there must be a concrete risk of loss or liability to the party claiming adversity. We were on the same side as HV2. We were simply trying to take the ball across the goal line because they ran out of money and the will to fight the case any longer. We were never adverse with HV2. And in terms of, and our whole point, I think to answer your second question, Your Honor, Schweiger versus China Doll, many of those cases, they say if claims within a lawsuit can be separated out so that you can determine what fees are attributable to both, they can and should be, if it's all one big lump. This isn't even a claim or defense. When we filed our motion to intervene, HV2 and the WEINBERG should have said, okay, intervene. Now we'll file a motion to dismiss. We're going to do whatever we're going to do. But the fees on the intervention dwarf any other recoverable fees. Of the $62,405 awarded to HV2, $46,725 of that was on intervention. Completely unnecessary action.
And when I looked at the record on appeal, it isn't clear to me that award didn't also include fees incurred in the prior appeal, at least as to HB2. I think that the record pretty clearly shows that Weinberg's fees did not include those fees on
And I think they did,
but the HB2 fees seem to include fees on appeal.
which were denied by the prior panel.
Right.
And then, and on the Weinbergs, they requested $87,205, they awarded $68,000. $30,660 of those were on the intervention. So obviously, if the motion to dismiss is reversed as we think it should be, the fees would go away, but at a minimum, if fees are awarded, it should be only to the Weinbergs and only for the fees that are about $38,000 that would relate to the proceedings on the motion to dismiss and our motion.
And so, I know you're running out of time. Why only to the Weinbergs? Why doesn't the court's finding that it would award fees under 341.01?
Because the Weinbergs that can invoke...
As HB2.
We believe that the CC&Rs can be read to apply to the Weinbergs,
Right.
and that's why. HB2, absolutely not,
Right.
and those have to be strictly construed, and we were never adverse to them under 12-340-101. So we would urge the court to reverse. We would ask the court to enter under the law of the case judgment in accordance with Judge Gamma's order, but at a minimum to reverse this and let it go back to be treated as appropriately following the motion to dismiss, to follow whatever proceedings might be, but certainly not just to simply have it thrown out without ever having a day in court. I'm happy to answer any other questions, and otherwise I'd like to reserve the remainder of my time.
Looks like you have about 4.5 minutes.
Thank you.
Thank you. Counsel, go ahead.
May it please the court, my name is Taylor Young, and I represent Richard and Lane Weinberg. At council table with me is Scott Holcomb, who represents Heritage. I think that the question of the court is that we've had in the during the appellant's argument is really instructive, that the court is reading this case exactly right. What this case comes down to is the orders that were entered in the prior litigation and what they actually held. And so, with the court's permission, I think it would be helpful to just very briefly kind of go through the previous history of the case and what led to those orders. The central dispute of this case, the one that raised all the issues, was the roof height, which I think the court is aware of from the questioning. And the issue was whether or not the Weinbergs had adequately gotten permission based on a document that said you have permission to build to the height of lots 26 and 27 or 19 feet. And Judge Gamma held in his preliminary ruling that that meant 17 feet. And so we've never had an opportunity to appeal that. I'm not here to argue that right now. But what Judge Gamma then did in that context is to order a remedial process that the parties were going to go through. He specifically retained jurisdiction, specifically ordered the parties to go through a remedial process, noted that part of the reason why he is ordering this process is that the court sits in law and equity. This is from the end of his findings of fact and conclusions of law, which is IR 40. As this court sits in law and equity in the interest of affording defendants due process in the remedial phase, so there's a remedial phase of this case, he ordered the parties to meet and confer to determine what remedial measures are, in fact, necessary to bring one into compliance. And as we've noted all throughout our briefs, the orders consistently throughout this as the parties are going to engage in the process. And I think the court, experienced judges on this court, can probably understand that some of Judge Gamma's findings and things that he noted, for example, were considerations in his next order after the parties were unable to reach agreement on that meet and confer. There was a second order, and that order came out, and the court directed that there were considerations that needed to be taken into effect for aesthetics, harmony, and conformity. And it's after that that he notes the roof height, specifically says the parties are free to agree to something else, That's where he notes the back patio and directs the parties to go into this process. And that is the process that we engaged in. And I want to specifically respond to counsel's suggestion that the first time that the board got involved in this case and looked at these things, the only time the board looked at plans and made decisions about plans was prior to the hearing with Judge Gama. I'd like to direct the court to, because I think it's a helpful document, this is Index of Record 133, and it is an index of exhibits that the WEINBERGs attached to their response to the motion to compel that ultimately ended up in Judge Hagee's order. And Judge Hagee's order was the order, as the court will recall, that says the parties are now going to be on a 60-day cycle until the parties settle. But that index points to exhibits, including the approvals and a bunch of pictures of the neighborhood, which goes to the Weinberg's equitable arguments about whether or not it's fair and we're entitled to an equities hearing. But it also includes elevation drawings for the first submission, elevation drawings for the second submission to HV2, architectural plans for the third submission to HV2, a fourth submission, a fifth submission, and a bunch of correspondence in between, mostly between me and Mr. Freeman, who was then representing HV2. So the parties were hot and heavy, going back and forth, trying to come to an agreement. It was hotly contested, and that's what ultimately ended up with HV2 filing a motion to compel, and it brought us before the court. If the court looks to the record to see, well, where are the other plans that happened after that? Well, they're not in the record, because we didn't have a dispute. There was no motion to compel. There was no argument that the parties weren't operating in good faith. So there's no reason for the plans to be that the parties were submitting back and forth to try and resolve this case and to be in the record at that point. But I can point the court to the settlement agreement. And the settlement agreement specifically notes, and I think these are important provisions, the settlement agreement notes that these changes are going to be made. Specifically with respect to the patio, it references Exhibit 2 to the settlement agreement. Unfortunately, the one in the record is just a document that says, Exhibit 2 simply says rendering and picture of back patio cover renovation, and that's because the document was just too large for the filing. But we did submit it. We submitted plans. They're referenced in the settlement agreement itself. I would also note that, contrary to, go ahead.
Just ask a question. As you're going through the settlement, can the HOA, HV, agree to a condition that is an absolute violation of the cease and desist?
An objective violation of the cease, in which the board doesn't have discretion, right? So it would be an area in which the board doesn't have discretion to grant an exception, isn't part of architectural review process. I mean, I don't need to change your hypothetical, Judge Goss.
No, I understand what you're saying. I'm going to use, all houses have to be painted white. And the board approved the house painted purple.
Okay, all houses have to be.
I'm choosing that, so there's a
I hear
bright
you.
line. That's
It's a
what I'm-
bright line, and it's not under the architectural review provisions. It's like a separate use restriction, which we noted on the film. We noted that there's certain.
No more than $4.
Right, there are certain, and that don't appear to be, to allow for discretion on the board. I would say in a contract case against the board, to require the board to bring litigation against the violating party, that you would have an argument there, and that is, and those are the facts.
Even if they issued an order approved.
Well, I mean, we had this letter in, I can't remember if it's spelled right now, or,
I'm just using my hypo.
oh yeah, I hear
The
you.
order,
Right.
saying you can have 17 dogs. We've changed our mind
Prior to litigation.
prior to litigation.
Right, well then that's not this case,
All right,
I
well,
don't
let's say I get 17 dogs, the board brings a violation, we go to court, everything's happening just like before.
Mm-hmm.
But at the end, the board ultimately he says, okay, I know it's the CCNR say 4, but you can have your 17 dogs before.
Well, I think
And they do that.
if the parties settle on those terms, I think that you're dealing with certainly different circumstances that we have here.
To me, that's what they're arguing.
No,
The board can't agree to a condition in a settlement agreement that violates the CCNRs. If the board wants that, the board has to amend the CCNRs.
It violates an objective provision of the
Exactly.
CCNRs. And again, that's why and by the way, that's why their case has changed from their initial intervention. By the way, the complaint and intervention that was submitted is not the same complaint and intervention that they actually filed, but nonetheless, their case has changed and morphed to be this violation.
Let's come back to my question, which
I
is
apologize.
one. Can the board approve a clear violation of the CCNRs in a settlement without facing a consequence? In other words, that another homeowner could come in and say, well, you just approved a mini manse in a trailer park. And the only thing allowed in here is trailers.
Yeah. I mean, Judge Gus, I have a hard time, without referring to statutes, I have a hard time saying that that's a hypothetical that we could stand behind if it's a specific violation.
Well, then let's turn,
So-
I'm sorry, go ahead, Judge.
So my point is,
I understand.
if they're right on the wall, if they're right that the wall couldn't move, and there was no provision or discretion on the board's part, is that a violation that can stand?
I think well, first of all,
I'm asking you to assume they're right.
Right.
Like I did him.
I hear you.
Make an assumption.
yeah, is that a violation that can
That you
stand?
can agree to. In other words, the rules are clear. Assume, not asking you to concede.
Right.
Assume that the wall can't move. Can the board agree to letting the wall move in the settlement if it's a violation of the CCNR?
I think that I think in the context of bringing a lawsuit against HV2 to require compliance, the case law would support the position that the boards, that would be a breach of contract. I'm sorry to hedge, Your Honor.
That's where I'm at.
Right.
Because if it's not allowed under the CCNRs, the board can't do it. But as long as it falls within the CCNRs and the board's discretion, they have the ability to.
And I think if you look, and I think in terms of a judicial interpretation of the contract, it's clear that the contract here does provide the board broad discretion, and it's the board's mechanism to make these changes. And also, just to be really clear, in below, the defendants interveners were really clear that they said, at no time have interveners suggested that the court-ordered changes are based upon express provisions in the CCNRs. That's in their reply to their motion for entry of final judgment. So they argued below that they are not arguing that there's a violation of a specific provision. They've changed that argument on appeal, and that's one of the problems we have, is we have this rewriting of the orders, we have a rewriting of the CCNRs, we believe, and now a rewriting of their own positions. Because below they said there's no objective provision. And by the way, earlier in the argument, counsel conceded that Judge Gamma never ordered the wall to be moved back. Court asked him that question, he said, right, it was never ordered for the wall to be moved back. So
Let's build upon Judge Goss's hypothetical, but actually turn this to Article 6A. It's a facially, at least, compelling argument that it says no hedges or walls shall be erected or maintained except as such were installed in accordance with the original construction of the building.
Right.
Correct? You have, I think it's undisputed now, a wall that is at least 1 foot outside of the original wall constructed in the building.
well, again, let me be really clear.
Yes or no?
It is a wall that is approximately 1 foot, right, into what is the former patio area. That's the encroachment.
It's
And it's
not-
not a property, it's not the property lines or any of that sort. I just want
I
the
get
court to
that,
be
but
clear.
it's not in accordance with the original wall. There has been a wall moved a foot out.
But the walls that are being referred to in that provision are exterior walls for patios. That's why we're talking about hedges.
Well, elsewhere in the CCNRs, when you want to talk about exterior walls, it specifically says exterior walls. Here we say hedges or walls.
Right, but that's, okay, I'm going to be real clear. Exterior walls of the structure versus exterior walls, meaning walls and hedges, right?
I know that's your argument, but
Fair
there's no word exterior in this section, so we'll move on now. Why isn't that a prohibition? Assuming that you interpret it the way I am, which is that this says walls, walls is walls. Why isn't that a prohibition?
Because for the exact reasons that you suggested, Judge Morse, which is the next sentence that says, except as unless the board allows it, right?
Well, it says any exterior changes, modifications, additions, or deletions
Right.
must have approval of the AC and the board.
which suggests that that those things can be done. Otherwise, there'd be no mention of the fact that you have to have approval by the ACC and the board. And by the way, Your Honor, just to be really clear, because I don't want to lose it, the settlement agreement, paragraph 4 of the settlement agreement in the section after the recitals, which is page 4 of the settlement agreement, reads, upon full and timely completion by the Weinbergs of the agreed remedial measures, the Weinberg property shall thereupon be deemed in compliance with the AC CNRs and the CCNRs. So that's an approval.
Isn't there another section of CCNRs that says if someone submits architectural approval and it's not responded to,
Sure.
that is the property thereforth and thereafter shall be deemed in compliance?
Yes, it's a very loose system. It's sort of like approval by estoppel. We actually argued this in the case below, that we had submitted plans and that the time had lapsed before we got a response.
That's not
I know,
before us.
I understand.
Okay.
I'm familiar with that provision, Judge Morris, echoing your comments from earlier.
So, again, though, there's other provisions or other sections in the CCNRs, though, that are more explicit on except as, which you tried to read into it earlier when I was asking you to describe this section. I get your argument that's an implied except as, because it's the next sentence, and what could it be approving otherwise? But why wouldn't we kind of say, well, when the CCNRs want to explicitly say except as provided, and they didn't do it here, then maybe we shouldn't interpret it that way.
Because I think if you look at the, I apologize, let me grab my CCNRs real quick. I want to get you the right provision. If you look at Article 3 of the CCNRs, which has the Architectural Committee's authority, that whole section is designed to make the Architectural Review Committee have the authority to make all of these decisions. And so it makes sense that even in an outside provision, we have two types of use restrictions, right? In our brief, in the discussion of Feller, we talk about the two different types of use restrictions, right? One use restriction says you have to only have normal pets, right? Another says you have to install satellite dishes in accordance with FCC regulations and our regulations unless the board allows you to do otherwise, right? But you would be submitting to the board under their power, under their Article 3 power to address all changes. We would go in through that process, right? The board would be looking at conformity and harmony in those satellite dishes as well.
So it's a combination of the grant in Section 6A in Article 2 and the broad grant of authority in Article 3 that gives you this.
Because that's the process. And how would, I mean, and to be perfectly frank, like how would the ACC and board sort of understand that process? I mean, this is a homeowners association, right? The process comes to them for certain approvals, so they're going to treat this all the same. And I think they would have the right to. If that satellite dish is not in harmony, in conformity with the rest, then they could deny it, which is the express power that they're given.
You've got about 2:45 left.
Right.
Let's talk about fees, because I read the court's order below as granting, at least as to HB2, some of the fees they incurred on appeal. Am I mistaken on that?
I think I might need to defer to Mr. Holcomb to
All right,
answer that
I'll
question.
let Mr. Holcomb answer that.
Thank you, Your Honor. Scott Holcomb on behalf of the HV2 board. Yes, the fees there included, did include fees on appeal, because those were not, the prior court order didn't grant fees on appeal because there was no prevailing party yet.
It specifically denied your fees on appeal, so thank you for clarifying that for me.
Yes.
Now on to the issue of whether the fees incurred in intervention at large, both below and on appeal. Is that a separate and distinct matter, or is that just part of this litigation?
It's not a distinct matter, more like having any other procedural matter of trying to establish early on in a case whether the case can go forward. And in fact, the award of fees to HV2 in this case is mandatory because it's important to note that the action by the board to deal with the design and the architectural issues was done. We'd settled it. The only thing that was going forward was the owner's attempt to try to usurp the architectural discretion of the board. In fact, their complaint said you have to deliver the plans to them for their approval. They had to agree. That's nowhere in the CC&Rs. So we were clearly adverse. They kept saying, that blaming the board and saying the board can't do this. Clearly adverse. In an action brought by
The
them.
CC&Rs do not provide for any award of fees to HV2.
Yes, they do. They expressly provide, because we're a prevailing party in the owner's action to enforce the CC&Rs. It says the prevailing party. That's the action we were litigating.
It says if, there's an if at the beginning of that. If the association takes enforcement actions, then fees shall be awarded.
But there's the second clause, you go further down in that statement, in an action brought by an owner, which is what they have done.
Right.
The prevailing party against the owners.
Against whom such action is taken. You did not take an action against.
Yes, they did. Well, actually, they did. We had entered into a settlement agreement to settle that lawsuit.
I understand your argument, but we're out of time.
If I may, one,
You can finish this then.
I appreciate it, Your Honor. They filed a separate action, and they dismissed it. They could have pursued a separate action, but they forced HV2 to continue going on and continue incurring these fees because of the settlement. We had settled our lawsuit. They didn't have to intervene. They did do a separate action, and if they had done that, they could have avoided those fees. But they took a position adverse to the board and tried to force the board to do something it had already decided was not in the best interest of the association. Thank you, Your Honor.
Thank you, counsel. We added on about 30 seconds there, so we're going to add on 30 seconds. So
Okay,
you've
and
got
I'll
about
try to be
5
brief.
minutes.
I want to address two major points. First of all, when I heard Mr. Young's argument, and he was talking about what was in the record and the settlement agreement, it was striking to me because we're talking about what's in the complaint and accepting the well-pleaded allegations of the complaint. And none of that falls within 12b-6. If we were arguing about a motion for summary judgment and discovery had been done and they were arguing there were no disputed issues of material fact, that all of those things had happened, then he might have an argument. But again, the trial court didn't even look at this case because she felt like because there was some discretion that existed on certain items that her hands were tied and she couldn't consider the case at all, which she didn't. So again, on the motion to dismiss standard, it falls under its own weight. I want to address, though, the issue that Judge Morse, you asked me about, and that I do think is important on Article 2, Section 6. First of all, we have never conceded that the change, they moved the rear wall, load-bearing wall of the house. They moved it outward. That changes setbacks. That is a major change. That is prohibited. And I'm going to read from Judge Gamma's order, which we have cited again and again, that says, defendants shall further change the location of the rear wall of the house, which is approximately 1 foot beyond the original footprint of the premises, back to the original footprint location. That was never complied with. That was a violation. And I think as to the question that you asked me, Judge Morse, that I may not have gotten to answering, Section 6, Article 2, Section 6, has 3 sentences in it. They are not all interdependent. The first one, except in individual patio areas, no individual planting or gardening shall be done. Okay, that's pretty easy. The next one, no hedges or walls shall be erected or maintained upon said premises except as were installed in accordance with the original construction of the buildings. That is an absolute prohibition. The next sentence, it says, any exterior changes, modifications, additions, or deletions must have approval of the Architectural Committee and Board of Directors, is not limited to or referring to moving an exterior wall. That's talking about changes generally. Of course changes. If I want to change the color of my house, I want to change my landscaping. That's simply stating that that has to be given approval. But Section C of, or subsection C of Section 6 says, notwithstanding B above, the association shall strictly enforce this restriction in any subsequent and future violations of this section in accordance with Article 8, Section 1 of this declaration.
How do you read that section in concordance with Section Article 3, which says, any addition, improvement, or any modification which alters the exterior appearance, excuse me, my inability to read, of the lot, whether a building, fence, or wall, or other structure, gives the broad authority to the committee and the board to approve those. So which one trumps? We've got two sections, and assuming your interpretation of Article 6A is correct, or Section 6A of Article 2 is correct, does that trump Article 3, which says they can change any wall?
Well, I guess the issue of statutory interpretation wasn't something that anybody addressed here. I would argue the more specific controls, but again, part of the problem here is the trial court didn't ever make that determination or enter into interpretation of the CC&Rs because she felt like her hands were tied entirely. But that's a pretty clear prohibition. No wall shall be built. And in this particular circumstance, if we're going to be talking about things that were in the record below, there were declarations.
But Section 3 specifically seems to contemplate some other wall being built, and that the board has the ability to do it. How do I get around that?
Well, but I think there's a difference, though. If you want to build a wall, perhaps it's not there, or a patio wall or something like that, I think you might be able to do it. But remember, this is saying walls shall be erected or maintained, no hedges or walls, except as were installed in accordance with original construction of the building. That exterior wall of the house was the original construction of the building. And remember, Judge Gamma agreed with HV2's interpretation that that was a violation of the CC&R. And he ordered that that wall be moved. And nobody's arguing that that wall was moved or that was remedied. And again, which takes me back to saying,
But Judge Gamma also ordered you guys to confer and come up with a compromise or a settlement. I mean, he never sought to enforce that order in the subsequent contempt hearings or the subsequent motions for enforcement to actually move the wall. He was still saying you guys got to come out a compromise on that.
true, now that was before my clients moved to intervene, but nobody's ever said that they were at loggerheads. They never reached an agreement, which is at the point in time where the board finally gave up and said, these people aren't going to make any meaningful changes. We don't have the money, and that's when our clients stepped in. So respectfully, I'm happy to answer any other questions, but we would ask that you reverse and remand this case.
Counsel, we thank each of you for your arguments. You've given us much to think about. We'll take the matter under advisement and issue a written ruling in due course, and we are in recess.